Ladies and gentlemen, Muhammad Ahmad Khan versus Shah Bano. In Muhammad Ahmad Khan versus Shah Bano, basically the brief fact of the case are that Muhammad Ahmad Khan and Shah Bano were married with each other according to the Muslim personal law. Two children were born from the wedlock, and after some time, due to the friction in the relationship, Muhammad Ahmad Khan divorced his wife, Shah Bano. Parties were from the Indore, city of the Indore. Then after the uh, dissolution of the marriage, divorce, the husband divorced by talaq biddat or triple divorce. Talaq triple divorce was pronounced by the husband upon the wife, and thereby marriage was dissolved. And after the dissolution of the marriage by 3 divorces, the husband also made the customary payments to his divorced wife Shah Bano. Means the unpaid amount of the dower was paid to her, and all the belongings which were brought by the wife at the time of the marriage, they were also returned to her. And at the time of leaving the matrimonial home, the wife was also given some customary payments. Feeling aggrieved, the wife Shah Bano filed a suit in the lower court of district Indore, and the lower court passed a decree of maintenance, awarding her monthly maintenance of rupees 188. Then the husband, feeling aggrieved, moved a revision petition before the district judge, and our district judge also upheld the decree passed by the court of the magistrate, awarding the 188 rupees per month as maintenance. Then a husband went to the High Court, and from High Court again the matter landed before the Supreme Court. And by way of the reference, a bench led by the former Chief Justice of India, Y.D. Chandrachud, decided the case of Muhammad Ahmad Khan versus Shah Bano. I have already discussed in detail Muhammad Ahmad Khan case. In Muhammad Ahmad Khan, the main argument of petitioner was that under section 125 subclass B, 125 subclass 1, a magistrate may pass a decree awarding the maintenance to a wife who is unable to maintain herself or has been neglected by husband, who has been neglected or has been refused the maintenance. And according to the Muslim law, wife means a wife who was married according to the wife means a woman who was married according to the Muslim personal law, and marriage can't subsist and continue. And in case of the divorce, she will continue to be treated as a wife only up to the period of the iddat. On the expiry of the period of the iddat, the wife will cease to exist as a wife, and therefore her right to maintenance will also cease to continue after the expiry of the period of the iddat. This was the one point of the argument. Other point of the argument was that under section 127, a magistrate is liable to cancel the maintenance order passed under section 125 subclass 1 if it is proved that maintenance was given to her during the period and all the customary payments were made to the divorcee during this period. Therefore, the Muhammad Ahmad Khan, the petitioner Muhammad Ahmad Khan, argued before the Supreme Court that his wife Shah Bano was divorced according to the Muslim law. His marriage came to end on the expiry of the period of the iddat. Until the expiry of the period of the iddat, she was paid the maintenance by the husband Muhammad Ahmad Khan, and not only maintenance but during the period of the iddat, she was also paid all the customary. She was also given all the customary payments, including the unpaid dower, etc., etc. And therefore, argument was that wife Shah Bano is not entitled to the maintenance after the customary payments in view of section 127. Therefore, magistrate was liable to cancel the maintenance order which was passed under section 125 subclass 1. Further, since she ceases to be wife according to the Muslim law, and therefore her right to maintenance also, and there is a conflict between Muslim personal law and CrPC, because under CrPC the definition of the wife is different from the definition or meaning of the wife as conceived under Muslim personal law. So there is a conflict between Muslim personal law and CrPC, and said that Muslim personal law, being the substantive law, will prevail over the CrPC. And therefore, Shah Bano, the respondent, is not entitled to any kind of the maintenance after the expiry of the period of the iddat in view of Muslim personal law, read with or vis-a-vis section 127 of the CrPC. Matter was heard at length, and Supreme Court of India, speaking through the then Chief Justice of India, Y.D. Chandrachud, held that there is no conflict between Muslim personal law and CrPC. Court clarified that Muslim personal law contemplate a different situation, a situation wherein after the divorce, divorcee is capable to maintain herself out of her own resources. And if this is the situation, husband is absolved from the responsibility of the maintenance. But section 125, which is based on the socio-economic justice to the women, gender justice to the women, it contemplates a different situation, that is a situation wherein after the divorce, divorcee is unable to maintain herself out of her own resources, and there is a possibility of leading a vagrant and destitute life depending upon the other people, and therefore Muslim law visualizes one situation, and section 125 basically is a social provision and is seeking to address a social problem, and therefore it takes care of a different class of the women of a given society, and therefore there is no conflict of Muslim personal law. If the wife after the divorce, expiry of the period of the iddat, is able to maintain herself, liability of the husband will cease to exist on that very point. But if the after the expiry of the iddat of the period, divorcee is unable to maintain herself, then in that very situation law will come to her rescue, and she will be entitled to maintenance even after the expiry of the period of the iddat till she remarriages. And the court defined what is the marriage, what is the dower, what is the maintenance, all these things were discussed. But in substance, the maintenance, the scope of the right of the maintenance in Muhammad Ahmad Khan versus Shah Bano was extended to cover a vacuum situation, a situation that was likely to force the wife to lead a destitute and vagrant life. So this is a social problem, and this problem was increasing day by day in the society. Therefore, in order to contain the further worsening situation, Supreme Court held that under Muslim law also, liability will not cease to exist on the expiry of the period of the iddat. Rather, it will continue even after the expiry of the period of the iddat, provided the wife was unable to maintain herself out of her own resources. Ladies and gentlemen, this led to a lot of the hue and cry, and ultimately Rajiv Gandhi government enacted a new law on the subject of maintenance, that is known as Muslim Women Protection of Rights and Divorce Act 1985. 1985. And section 3 subclass 1A was enacted under the scheme of this act, and under this provision the liability of the maintenance, the duration of the liability of the maintenance for a divorced Muslim wife was codified. And according to the spirit of this provision, the liability of the maintenance of a divorcee for a divorcee is not limited for the iddat period, rather it extends for entire life of the divorced wife unless she remarries. The court also held that the response that reasonable and fair provision would be worked out. This is also provision, because section 3 subclass 1A makes the two provisions. One, that husband after the divorce, Muslim husband is required to pay the maintenance on reasonable scale to his divorced wife during the whole period of the iddat, and during the period of the iddat he will also make a fair and reasonable provision for her future needs. Therefore, the court held that if the husband has paid maintenance and made the provision for the and has made a fair and reasonable provision during the iddat period, then the liability of the husband will come to an end. If the husband has failed to provide the maintenance during the iddat period or has paid the maintenance during the period of iddat but has failed to make a fair and reasonable provision for her, liability will continue even beyond the period of it. And the court also explained what is the fair and reasonable provision in context of section 3 subclass A having regard to the divorced wife. The court in the Daniel Latif versus Union of India clarified. Fair and reasonable provision means the provision made by the husband during the continuance of the iddat period which will be sufficient and enough for the contemplated arising material future need of the divorcee. Therefore, if the provision, fair and reasonable provision pursuant to section 3 subclass 1A has been made by the husband during the period of the iddat which is sufficient to meet out the likely needs of the wife in rest of her life, then it will be treated as a fair and reasonable provision, and in that very situation the husband will be absolved from the responsibility of maintenance beyond the period of iddat. If the husband has failed to make the fair and reasonable provision during the iddat period or has made the fair and reasonable provision during the iddat period but is not sufficient to address or to meet the arising future contemplated need of the divorcee, it will be violation of section 3 subclass 1A on the part of the husband, and therefore husband will be still under the liability to pay the maintenance to a divorced wife even after period of the iddat. This type of the interpretation was given and explained by the Supreme Court in Daniel Latif versus Union of India so far as the right to maintenance of a Muslim divorcee after the expiry of the period of the iddat is a concern. Controversy was set at rest in Post-Muslim Women Protection of Rights and Divorce Act 1986 because perception was that after enactment of Muslim Women Protection of Rights and Divorce Act 1986, Muslim husband will not be required to pay the maintenance to his wife, divorced wife, after the expiry of the period of the iddat. But in Daniel Latif versus Union of India, the point was made further clear by giving the interpretation to section 3 subclass 1A, particularly expression maintenance and fair and reasonable provision. Maintenance means everything which may be required to the wife for leading a dignified life after the divorce. So the husband will have to make the arrangement for all those things which may be necessary for the good life of the divorcee after the pronouncement of the wife after the pronouncement of the divorce. And this will be decided having regard to the requirement of the wife, need of the wife, as well as the financial condition of the husband and the social condition surrounding the wife or divorce. Not only this, the court also clarified that the husband is required not only to provide the maintenance, but he is also under the obligation, because the word and, the section 3 subclass 1 says that husband will pay the maintenance and will make the fair and reasonable. Means a husband under section 3 subclass 1A with regard to his divorced wife is under the two obligation in view of section 3 subclass 1. One is that he will pay the maintenance on reasonable scale. At the same time, he will also make a fair and reasonable provision during the period of the iddat, and fair and reasonable provision was also explained by the court. And in this way, four propositions were laid down by the Supreme Court in Daniel Latif versus Union of India in concluding part of its judgment. And it was that a husband is required. One was that husband will pay the maintenance to his wife during the iddat period. Further, the husband will make the provision will make a fair and reasonable provision on or before the expiry of the period of iddat. During means on or before the expiry of the period of the iddat. If these two obligations are fulfilled, the responsibility of maintenance will cease to exist beyond the iddat period. If the responsibility has not been discharged by the husband, then the liability to pay maintenance to his divorced wife will continue even beyond the period of iddat in view of section 3 subclass A. This future provision must be made within the iddat period in terms of section 3. It was made clear. Now friends, after Daniel Latif, so many cases has been decided by the Supreme Court on the topic of the maintenance of a Muslim divorcee. One of such cases, Iqbal Bano State of UP 2007. The Supreme Court, following the guidelines laid down, judicial guidelines, a legal proposition laid down by the Supreme Court in Daniel Latifi case, reiterated the legal position that liability of a Muslim husband to his divorced wife under the section 3A Act is not confined to the iddat period. He is liable to pay the reasonable and fair provision for the future of the divorced wife, which obviously includes her maintenance as well as future provision for her contemplated needs arising in the given situation. For disposal, Chand Patel versus Bismillah Begum. The fact which give rise to a aforesaid question in brief are set out under. The respondent number 1 herein, Bismillah Begum, filed an application for her maintenance and for maintenance of her minor daughter under section 125 of the Code of Criminal Procedure. Now in her petition, she claimed that she was legally wedded wife of the appellant and that her marriage with the appellant had taken place. The petition number 2, Post-Shah Bano, being the minor, is under care and guardianship of her mother, the petitioner number 1 in this set of application. In her petition, the respondent number 1 herein categorically admitted that appellant here was married to her elder sister, and that appellant with the consent of his first wife married the respondent number 1, and the nikah nama was also executed, but same had been misplaced. It was also admitted that appellant here lived with his first wife and respondent number 1 under one roof, and appellant had even accepted the petitioner number 2 as his daughter and brought her up. The court held that unlawful conjunction and our marriage between the appellant and respondent continues to subsist and not having been declared void by any competent forum, and accordingly the respondent number 1 and the respondent number 2 will both be entitled to maintenance under section 125 code of the means the petitioner Bismillah Begum was allowed to be entitled to maintenance under section 125 of the Code of Criminal Procedure Code. The appellant shall pay to the respondent all the areas of maintenance within the period of the 6 months from the date of his this judgment, and will also go on paying the current maintenance with the effect from March 2008. In addition, the appellant will also pay to the respondent a sum of rupees 10,000 towards the cost of the litigation. Then there is another case, Zubair Ahmed vs. Ishrat Bano, 2219, on the subject matter which may be of great use for the learners if they goes through this fact of this case. The Supreme Court has laid down a law that divorced Muslim lady is entitled. In this case, the court laid down that Muslim lady is entitled for maintenance under section 125 or CrPC. When she came to know this law, she immediately filed this petition. She is a domestic woman and totally dependent on her father. In April 2010, her father died, and since then she is in the serious financial trouble and is not able to maintain herself. The husband is teacher in government school and is earning 25,000 in a month, and therefore she claims to be 10,000 and maintenance. Opposite party filed the written statement and admitted the marriage and birth of the daughter. He has also stated that on such and such about after he divorced her wife, by the order of the court, he gave maintenance of 13 months and expenses till the period of iddah. The amount of the dower of rupees 11,786 was paid by him very first night of their marriage. Thereafter, nothing remained payable by him to her, nor she is entitled to any further customary payment. She is an independent-minded woman, and she always insisted him to live with her parents. The wife is arrogant. These were the allegations which were made out in order to counter the claim. But the issues were framed, and the court held that family court's decision to award the maintenance to Ishrat Bano, a divorced Muslim wife under section 125 of the Code of Criminal Procedure. The court affirmed that despite the provision of Muslim women protection or rights in Divorce Act 1980, and a Muslim woman is entitled to maintenance. Shami Mara versus State of UP is another case important. Now, ladies and gentlemen, a path-breaking judgment on the topic of maintenance has been given by the Honorable Supreme Court in 2024, which is known as Abdul Samad versus State of Telangana and others. In this case, the Supreme Court of India has held that at the end of the court and at the end the court of law concluded if Muslim women are married and divorced under Muslim law, then section 125 of the CrPC as well as the provisions of 1986 Act are applicable. Option lies with the Muslim divorced women to seek the remedy under either of the two laws or both the laws. This is because of 1986 Act is not in derogation of section 125 of the CrPC, but in addition to said provision. The Supreme Court ruling in Abdus Samad case clarified that Act does not prevent divorced Muslim women from applying for the maintenance under Section 125 of the same. The ruling also affirmed that secular statutory provision of Section 125 cannot be superseded by the Muslim Women Protection of Rights and Divorce Act 1986, which is the special law on the subject matter. So this case laid down a new proposition of law, and that before this judgment, after the divorce, Muslim divorcee was entitled to claim the maintenance by invoking the provisions of Muslim Women Protection of Rights and Divorce Act 1986, not under Section 125 CrPC. But under Section 4 it was given that in any case where the parties wanted to be governed for maintenance under Section 125, a joint application should be moved before the court stating that with their mutual free consent they are in agreement that their matter should be decided under Section 125. So means in order to invoke in ordinary course of the circumstances, divorcee, a Muslim divorcee was entitled to claim maintenance only under Section 3 subclause AB of the Muslim Women Protection of Rights in Divorce Act 1986. But where there was a joint application by the parties expressing the desire to consider their case or decide their cases under Section 125, only then court could entertain a maintenance application under Section 125. Otherwise, if there one party wanted to be governed under Section 125, other party wanted to be governed under Muslim Women Protection of Rights and Divorce Act, then court would take a position that parties will be that matter will be decided under Section 3 subclause A of the Act. But and now after this judgment, a way has been paved clearly by the Supreme Court for the Muslim divorcee. And now after this decision, option rests with the Muslim divorcee. She can invoke Section 3 subclause A of the Muslim Women Protection of Rights and Divorce Act 1986 for the purpose of claiming the maintenance after the dissolution of her marriage from the former husband. Or she can invoke Section 125 subclause 1 of the old CrPC, now it is Section 144 perhaps. So now there is a absolute choice. Absolute choice has been given to the divorcee, Muslim divorcee, either to claim the maintenance under the 1986 Act or under the Section 125, now Section 144 of the new code. So therefore this judgment is a path breaking judgment. And path breaking judgment is in the sense that choice of the wife to invoke the provision for the maintenance has been widened. Earlier it was a consent of the to be governed under Section 125, the consent of the husband was necessary, but now consent of the husband is not necessary. It is the choice of the wife to claim the maintenance under Section 125, now 144, or under the provisions of 1986 Act. Ladies and gentlemen, this is the journey of development of law of maintenance starting from 1970, Shah Bano to the Abdul Samad uh, case of Abdul Samad versus State of Telangana 2024. The journey of law development of Muslim law and maintenance of courts is interesting, and hopefully it will enrich the knowledge of the learners on the topic maintenance, which of course has been a controversial topic from bar to bench, from the student to the researcher. But now the uh, uh, gradually the controversy has been set at rest by the successive judgments of the Supreme Court, and the judgments of the Supreme Court basically are based on are based on social justice, on gender justice, as well as the justice to the weaker segment of the society who have been sufferer for decades in a country like India. Thank you very much.